So in Nevada, if there is a dispute in the family or among the beneficiaries of an estate, you have options. One is that if all of the beneficiaries and heirs can get together and strike an agreement, generally that agreement can be enforced by the court, even if it's different than the precise terms of the will or the trust. The second option is that if there's a desire to negotiate an outcome, then you can take that to a settlement conference or to a mediation, and a sitting judge or a retired judge acting as mediator will get the group together and go back and forth and help you carve out an agreement with the assistance of your attorney. And that's a great option for resolving a contested estate. And in both instances, the agreement that you reach either with the assistance or without the assistance of a mediator can be approved by the court, which will give it the authority close to that of a court order. So mediation and settlement conferences in a contested estate situation, it's a very effective process in which the participants usually leave feeling like their concerns have been heard, their needs have been heard, and people understand what's driving their needs. And they usually leave understanding the perspective of the other side to the dispute as well. And there's something about the process that just works. You get a lot of truth in a process like that because the person who's a mediator is usually a retired judge or a sitting judge, and they'll come in and talk to you and they'll tell it like it is. They'll tell you how unfun the process is going to be, how expensive the process is going to be. They'll remind you that right at this moment, you have the opportunity to shape an outcome that, you have more control over the outcome as a negotiating party than as a litigating party. And putting that all together, I would say about 90% of the cases that go into mediation usually reach an agreement that's satisfactory to everybody. So arbitration is different than mediation. Arbitration is you're handing your dispute to a private judge, basically. And one of the pros of arbitration is that your private judge is going to know probably more about your kind of dispute than a regular sitting judge that hears all kinds of cases, criminal, divorce, whatever. Your private judge will be more focused on your kind of dispute. The second pro is that the process is highly confidential and it's not going to be in the public eye. Whereas if you're in court, everything that gets filed is available for public inspection. And, the public will see your family business. One of the big cons for arbitration is that it's an expensive process because in addition to paying your attorney, you're paying for your private judge. And you keep feeding you keep putting quarters into the machine as the process goes along. So the question is, can family negotiations prevent contested estate litigation? And the answer is yes. And then the question becomes, well, why don't more families, prevent contested estate litigation by negotiating? And the answer to that is there are lots of family dynamics that sometimes keep people from coming together, in good faith to resolve a family dispute. And sometimes family members, they just need a little bit of help to get to that point. And so one likely outcome is that there are disagreements. They do go seek their counsel, and sometimes they do go to court. And then either the court or the attorneys can help the family members to find a structure, to have a structured negotiation and resolve their dispute. Resolving family disputes in contested trust matters is a topic that's near and dear to our hearts at Sierra Crest Business Law Group. We want to help you find that resolution. So if you have any questions about how to go about that and what it's going to take to really bring peace to that situation, give us a call.